pleased to have Therese Stewart, who is the Chief Deputy City Attorney for the City and County of San Francisco, position she has held since 2002. She oversees the office's civil litigation and represents San Francisco and its officials in key cases. From February 2004 to May 2008, she was particularly busy with a certain type of case that were the in re marriage cases, which were litigated in state trial and appellate courts. She presented oral arguments in the California Supreme Court, and that court in May of 2008 held that the exclusion of same-sex couples from marriage unjustifiably discriminates against lesbians and gay men and denies them fundamental liberty and autonomy, privacy interests in entering into state-sanctioned family relationship, equal in dignity to other state-sanctioned family relationships. But this is California, so shortly after that opinion, the California voters passed Proposition 8 in November of that year, restricting marriage to opposite-sex couples, and Ms. Stewart then led another team of attorneys challenging the measure in California California Supreme Court. And she has subsequently a federal case was filed, and she's been working with the lawyers in the federal case as well, and helped them moot their arguments before the U.S. Supreme Court. And we'll hear more about that today. Prior to joining the city attorney's office, she was a partner at Howard Rice, where she handled complex business litigation in state and federal courts for over 20 years. She also worked on a number of pro bono projects involving poverty, veterans, and LGBT discrimination. In 1989, she served as the president of the Bar Association of San Francisco, at that time the first openly gay person to serve as a BASF officer. She then, along with then executive director and our former dean, Drew Ramey, co-founded a school-to-college program, which involves mentoring and guidance to inner-city high school students to help prepare them to apply for college and for college. She's been honored with many different awards, and she even came to Golden Gate to moot for her California Supreme Court arguments to a packed audience in a double lecture hall on the second floor. And when she was arguing before the Supreme Court, we had live streamed in our classrooms, and we were all watching it as well. And we're also very pleased that her wife, Carol Scagnetti, is here and is also a Golden Gate alumna. Conducting our In Conversation with Ms. Stewart is Diana Richmond. Diana Richmond got her law degree at Golden Gate Law School, and has been a partner, a certified family law specialist for 32 years, and since 2001 she has been a partner at Sideman Bancroft here in San Francisco. She has a breadth of experience in nearly every aspect of family law, just to name two, for example: complex marital property issues, and premarital and marital agreements and appeals. She works as a mediator, settlement conference facilitator, private adjudicator for family law and related controversies. She has been recognized for 30 years as one of the best lawyers of America, and was named by that publication as the San Francisco Family Law Lawyer of the Year in 2009 and San Francisco Family Law Mediator of the Year in 2012. She received the Hall of Fame Award from the Association of Certified Family Law Specialists. She was trial and appellate counsel in California Supreme Court same-sex parentage case of KM versus EG, and has written amicus briefs in a number of cases to end the ban on same-sex marriages. Indeed, she and Louis Factron, who's here today, and Richard Rosenthal filed an amicus brief on behalf of the American Academy of Matrimonial Lawyers and the Association of Certified Family Law Specialists in the recent Supreme Court same-sex marriage cases, focusing on children. And some of you who listened to the argument might have heard that the issue of children came up in the argument, and that for the sake of children, same-sex couples should be recognized, and that Proposition 8 should be held unconstitutional. She has been a dedicated and generous alumna of Golden Gate, frequent supporter of our programs, and previously served on our Board of Trustees. So we're delighted to have both of them here.
honored to be on this program with Therese Stewart, who has long been a hero of mine, and who I credit for getting me involved in doing the first amicus brief that I ever did, which I found to be a most inspiring experience. Dean Van Cleef has given us a little bit of a backdrop of Hollingsworth v. Perry. Could you just give us a brief summary of that case as it was positioned before the United States Supreme Court, as well as Windsor, and then we'll go on into more specific questions.
Sure. So, as the Dean indicated, the Proposition 8 passed in 2008, about 5 months after same-sex couples were first permitted to marry in California. And after a skirmish in the California Supreme Court that had to do with esoteric election law issues in which we failed to get rid of Prop 8 that way, Ted Olson and David Boies, on behalf of two couples, filed the Perry suit in the federal district court here in San Francisco, challenging Prop 8 on federal constitutional grounds, which was really the only avenue left to challenge them after what had transpired in California. So that case, the city intervened in that case, and we didn't originally intend to. We intervened because Judge Walker decided to have a trial, and he decided to have a trial on very short, a short compressed time schedule. So he set a trial date in August of 2009 for January of 2010 on a matter that involved potentially a great amount of expert testimony and on everything from what criteria you have to meet to get strict scrutiny or heightened scrutiny, such as whether you have the political power to represent yourself in the process, whether gays and lesbians are equally able to contribute to society, whether sexual orientation is immutable, etc. And also expert testimony about all the justifications that would be asserted or could be asserted in support of excluding same-sex couples from marriage. So because of the challenge of gathering that and our familiarity with the experts from our prior work in the California cases, the city jumped in and sought to intervene and were allowed to intervene. So we tried that case with Ted and David on a very broad theory where we advocated that excluding same-sex couples from marriage in general is unconstitutional. We prevailed in front of Judge Walker. It then went to the Ninth Circuit, and in the Ninth Circuit there was a little bit of a difference of strategy. Ted and David continued to argue the very broad position that excluding same-sex couples from marriage at all violates the federal Constitution, the equal protection and due process clauses. The city filed a separate brief saying we join in Ted and David's argument, we join in the plaintiff's argument, but we also think if the court isn't ready to reach that broad issue, there's a narrower way on which the court could resolve the constitutionality of Prop 8. And we argued in part that the unique facets of Prop 8 that carved an exception to the California Constitution for gay people only in the wake of the California Supreme Court decision, and the fact that California's family law in every other respect recognizes that same-sex couples form committed relationships, have children, raise children, and are equally good parents, and doesn't in any way discourage that and provides all the same supports that it provides to opposite-sex couples for having children, makes the idea that there's something about children that justifies Prop 8 uniquely irrational. So we presented that in our brief. The Ninth Circuit went with the narrower argument and ruled that Prop 8 was unconstitutional for this panoply of reasons that are somewhat unique to California, not because, again, that it didn't agree with Ted and David, but it didn't reach that broader issue. So fast forward, the case, meanwhile, by the way, while our case was pending, a case called Windsor and a series of other cases, Gill and Peterson and others, were pending that were challenges to the Defense of Marriage Act. And the Defense of Marriage Act was a federal law passed in 1996 that, in the wake of a Hawaii state court proceeding that looked like Hawaii was going to legalize marriage for same-sex couples. And Congress said, oh my God, that would be a disaster. we are going to adopt this statute that, even though we've always basically left it to the states to define marriage and accepted their definitions, we're going to adopt this law that says for federal purposes, for all rights and benefits and privileges and everything else that federal law tracks with or accords with marriage, we're not going to recognize same-sex marriages, even if a state or states should choose to do that. So the challenges to that law were sort of proceeding in parallel with the Perry case. And it happened that they both reached the U.S. Supreme Court at the same time. So the court granted cert in both cases in December of 2012, and they raised some of the same issues and some different issues.
Great description. In the Perry case, why do you think the United States Supreme Court took it, especially since the Ninth Circuit ruled on such a limited ruling that basically could be held to California alone? California, having granted all of these rights, could not, by a state constitutional amendment, then proceed to take them away.
I think the best sort of educated speculation about that came from an article that Adam Liptak wrote in the New York Times after the arguments in the cases was over. And he said, judging from the arguments, his best guess was that the more conservative justices voted in favor of granting cert. Remember, it only takes 4 justices to grant cert in the Supreme Court. And he wasn't sure whether Kennedy joined them or didn't join them, but he thought it was likely at least 3 of the 4 most conservative, maybe Roberts, maybe Kennedy, maybe not. And he thought that the reason they would have granted cert would be because they figured the climate wasn't going to get any better for their view on the merits, and that it was sort of like, if we have any chance of ruling the way we're inclined to rule, it's now or never. I'm describing Adam's position, but it's the best explanation that I've heard. It's hard to know, but one of the reasons that he speculated that or guessed that is because there were 2, and I think actually 3 justices at the court in the Perry argument who raised the question of whether cert had been properly granted. One of them was actually Kennedy. One of them was Breyer, and I think Sotomayor may also have said something, but in any event, the idea that, like, did we properly grant cert in this case? And then Scalia sort of dished back, well, we've crossed that bridge already. And so you kind of got the feeling that there was a little bit of dissension on whether cert should have been granted, and that the liberals were on one side and the conservatives on the other.
Having listened to the oral arguments in that case, there were at least half a dozen different points on which the justices were asking questions and coming from wildly different positions. And it was at that point, I think, that Justice Kennedy interjected, why do we need to decide this now, or something like that, and that led to that discussion. Which leads to my next question. Is it too late for them to decide it was improvidently granted?
It's not too late, but it's, I'm told, I mean, this is an unusual case. Okay, so the normal rules don't necessarily apply, but my colleagues, we have 5 deputies who clerked for various Supreme Court justices, and so they know a lot about the way the court works. And what they told me was, look, generally it's considered bad form if there was a 4-5 vote to grant cert, for any of the 5 to vote to dig the case, to dismiss it as improvidently granted, because the effect of doing that would essentially be to say, we don't care about the rule of 4, and to undermine the idea that 4 people can make that decision. So even though there was noise about it, and even though it's possible, I think they probably will try very hard to get to a resolution that a majority can live with, that resolves the case on either standing or the merits.
Could they have taken Windsor and resolved some of these issues without ever having bothered with Perry?
Yes, theoretically, they could have taken Windsor and resolved some of these issues. One of the things, though, that you heard in the Windsor arguments was, and this I found disheartening, was this kind of real focus on the 10th Amendment idea that by intervening on the issue of what the definition of marriage is after all these years of leaving it to the states, the Congress tread on the state's power in a way that's unconstitutional. And that's, you know, the pros and cons of the 10th Amendment are not why I was disheartened, although there are implications from that kind of a ruling that aren't always good. But it was the fact that they didn't seem to want to decide it on equal protection grounds that really troubled me. And I think, you know, yes, it's possible they could have taken it, they could have decided, and they still could, and decide on heightened scrutiny, that issue, and decide whether a lot of the supposed rationales that justify DOMA are similar to the ones that are used to justify denial of marriage. They're not identical, but they could very much foreshadow what they would do in a case like Perry in Windsor had the Perry case not come up at the same time.
Having taken them both, it seems to me they can't do something inconsistent in one from the other, and to some extent they box themselves in. For example, if they decide Windsor on the basis of the 10th Amendment, these are rights reserved to the states, and the federal government arrogated itself by saying there's only one definition of marriage across the country. If they knock it out on that ground, that then portends an outcome for the Perry case, doesn't it also?
I mean, in theory, in optics, yes. In principle, no. Because the 10th Amendment is about when Congress has the power to legislate, and the power of Congress to get involved in certain issues that have historically been reserved to the states, and that the states have historically been the primary, if not exclusive, regulators. The Perry case doesn't deal with Congress. The Perry case deals with the federal constitutional requirements of equal protection and due process. And so optically, you might say, well, how can the federal government, through the federal constitution, impose something on the states if Congress can't do it under the 10th Amendment? But the reality is that's what the Constitution is. It includes a Bill of Rights, and that Bill of Rights often trumps both federal and state statutory laws and state constitutional amendments, for that matter. And so there's not a principled inconsistency between the two, but there's sort of this optic, you know, well, is it up to the states or isn't it up to the states kind of idea that I think, you know, probably the public would have trouble grasping the difference.
Here's the piece I'm concerned with. And I got the sense also from listening to it that they were trying to dodge the equal protection argument on Windsor. If they decide that it's the state's province to determine the definition of marriage, then going to the Perry case, where one state hasn't defined it in a way, and the position on the challengers to Proposition 8 is that it is federally unconstitutional to deny marriage equality to same-sex couples. That then means that I guess the states could define marriage as they like, but that's not one thing that they can do when they define.
Right, and we have a whole history of cases in which the federal constitution has been held to, by the Supreme Court, to impose limits on what the states can do with respect to marriage. The one that everybody knows about is Loving versus Virginia, which is the interracial marriage bans that states had, most of them, many of them, any with appreciable African-American populations, dating back to the colonies. And finally, in 1967, the U.S. Supreme Court got around to saying that violates equal protection. But there are two other cases, Zablocki versus Redhale and Turner versus Safley, in which the court held that a state that said if you're in arrears on your child support, this was Wisconsin and this was Zablocki, you couldn't marry, that violated the fundamental right to marry that everybody enjoys. And so the federal constitution didn't let the state regulate marriage in that way. And also in Turner, the question was whether a prisoner had the right to marry. And the court said it's not completely inconsistent with the prison environment for a person to be married. There are both sort of spiritual and dignitary aspects about marriage and legitimation of a relationship that even if you can't consummate it, still have constitutional significance, and the state can't deny marriage, nor the federal government, to prisoners just because of whatever crime they've committed, because the right to marry is so fundamental. So it is true that you can have an area that is traditionally regulated by the states, but it doesn't mean that the federal Constitution doesn't impose a ceiling on some of the things that you can do with that sphere of regulation.
That Turner case is one of the best for the challengers of Proposition 8 because of the rationale offered by proponents of Proposition 8 for its rational basis. You want to tell us what the rational basis asserted for Proposition 8 is?
Well, the one that the proponents of Prop 8 mainly have advanced is that we don't know what will happen if gay people are permitted to marry, and it might cause some harm to the institution of marriage and or to society. We can't exactly tell what that is, but it's rational to be afraid of that it might happen. And that's good enough. And you don't need anything more than what they call rational speculation. But I think what you're getting at, Diana, is the argument
irresponsible procreation.
Right, that many people have made, and that they sort of soft pedaled for reasons we'll probably get into, but is that somehow because heterosexual couples procreate or procreate accidentally, that they are different from gay couples who either, in their view, don't procreate or don't procreate the natural way, so therefore heterosexual people need marriage because they're more likely to make kids by accident and be irresponsible. And gay people are so good that, as Kenji Yoshino said in an article once, like an op-ed in the New York Times, sometimes they argue that we're not good enough for marriage, and then they flip and argue that we're too good for marriage. And that's, so the we're not good enough argument is children need a mother and a father, and heterosexual couples are the ideal environment, the optimal parenting arrangement, and we can honor that and encourage it over this suboptimal thing of same-sex couples.
This argument is so good it bears further elucidation. The notion is that marriage is centered on responsible procreation, or marriage is centered on procreation, contrary to what Turner said, that marriage is a relationship between two people that connotes its level of commitment to one another and provides a stability and support system for life. So in the proponent's argument, procreation is at the heart of marriage, number one. Gay couples can't procreate. That is, they can't combine a sperm and an egg from one member of the couple and the other and make a child in that fashion. Another is that heterosexual couples irresponsibly procreate. They go sleep around and they have babies, which gay couples can't do because they have to intentionally have children. And the third piece of this is that children are optimally raised by their biological mother and father, a fact that is belied by adoption statutes, sperm donations, and the whole panoply of assisted reproduction that are used by both heterosexual couples and same-sex couples. How did the court treat this lovely argument in oral argument?
It's interesting. It was disappointing a little bit in that every time Ted tried to talk about what Kennedy dubbed the broad argument, somebody would say, in one instance it was Kennedy, and in others it was, I think, Scalia and maybe Roberts or Alito, oh, you're taking us into uncharted waters, you know, marriage has been around for millennia with opposite-sex couples, and, you know, there's only been a few years with gay couples. And in fact, the trial record has an extensive amount of expert testimony that dates back many decades, admittedly not millennia, but that show that same-sex couples, the children raised by them fare just as well as children raised by opposite-sex couples. And so he's, you know, the justices seem to be a little unfamiliar, I guess you would say, with the record. I'm hoping that in the meanwhile their clerks are busily reading away. But on the other hand, Kennedy made a remark about children that kind of was, he said, well, you know, yes, I'm concerned that, you know, the research on same-sex couples is too new, or the issue is too new. But on the other hand, you know, what about the children we know about, the 40,000 or more kids who are being raised by same-sex couples in California, and the very real harm we know that's happening to them as a result of their parents being denied marriage and the stability and all the good things that it brings. So he seemed to be saying, look, there's this uncertainty on the one side, but this certain harm on the other, which seems good. But the uncertainty isn't there. And one of my friends and somebody who's been a real leader in legal efforts to advance LGBT equality is a guy named Paul Smith, who argued the Lawrence case, which is the case where the sodomy laws were finally struck down by the US Supreme Court. But Paul wrote an article that was published in the HuffPo called The Well-Charted Waters of Same-Sex Parenting, and talked about how every major, the American Psychiatric, American Psychological Society, the Association, the National Association of Social Workers, the American Pediatric, whatever, you know, there's like this whole panoply of very prominent medically related organizations, all of which have said children of same-sex couples do fine and that they benefit from having their parents be able to marry. And so there's really scientific consensus. It's not a debatable issue, as I think Scalia called it, something like that. And the record showed that. So I'm kind of, again, hoping that the clerks notice that, happen to bring it to the attention of Justice Kennedy, or at least that somebody's reading the trial record.
By the way, when Justice Kennedy brought up the 40,000 children in California, he referenced the red brief, and I looked that up, and the red brief was Therese Stewart's brief from the same county.
Oh wait, tax brief is a red brief too.
It is?
Yeah.
There was only, I looked up the rules as to the color of the briefs.
Right.
And the only one that looked anything like red was yours. So take a little credit. It's in there. It's in there. I know it. I read it. But Justice Roberts had a really hostile question on this subject. He said, isn't there a contradiction between arguing that children are harmed by their parents' inability to marry, and yet you're arguing that such children are as well adjusted as those in opposite-sex couples? And it seemed to me our side faltered on answering that question.
That was posed to the Solicitor General, Verrilli, who actually was really terrific, but you know, as you might imagine, he's just been steeping himself in this case recently because they only decided to file a brief in support of our case recently. I mean, the answer to that question is straightforward, and I think hopefully it's not lost on most of the justices, which is, you know, yeah, discrimination hurts kids, having same-sex parents doesn't. They're two different things. But it is true that it wasn't, it didn't roll off the Solicitor General's tongue. But, you know, having him there was really valuable, regardless, and he did a lot of terrific work in the argument on other stuff. So,
the timing issue came up in oral argument. So to what extent do you believe the success in this case at the Supreme Court level may be hindered by years of backlash off of Roe v. Wade? In other words, the Supreme Court went out there, they decided an issue of real cultural importance. And instead of settling the issue for all time, people who felt disaffected by it stirred up, have threatened this challenge over the years. And apparently Justice Ginsburg has been heard to say that we should have learned a lesson from that.
Well, but Justice Ginsburg was making a very different point, which is the court shouldn't have taken the case. And in our case, the answer would have been to not take the case. But I don't think the liberal justices, if it's the case that they voted against cert, that if cert's granted and they're not going to dig it, that they're going to rule the wrong way because of a fear about that. What they might do is either two things. I don't think at this point, my best guess is that we will get a broad ruling on the merits. But I never thought that we would. Ted has thought that we would. I was hoping that he knew something I didn't know, which was likely since he knows the justices better than I do. But the reason I didn't think so is because we've always, as long as this case has been going, we've had 3, 4, 6, now 9 states that allow marriage equality, and 41 states at present do not. And that means that if the court makes a broad ruling, it's forcing 41 states to change their law. And if you look at, forget about Roe, if you look at the Loving case, if you look at the Lawrence, the sodomy case, in most of their big constitutional cases, it was by the time they got around to ruling, look, nobody can do this, it was at a time when there was only a minority. It was the reverse of what we've got. They had a minority of states that still had the bad law on the books, and a vast majority of states were already there. And part of the idea with the Supreme Court is like the courts are the least powerful branch. They don't control the army. They don't have a way of enforcing their decrees other than people's respect for the institution. And if they exercise their power in a really overreaching way, they've jeopardized the whole branch, really, and the way our government is structured. So we gave them two options besides, part of the reason we argued the narrow argument in the Ninth Circuit and hoped that the Ninth Circuit would bite on it, which it did, was because we wanted an alternative in front of the court where they could dispose of this case without making the broad ruling. But there was a second issue, which was the standing issue, which has to do with whether the proponents of Prop 8, after the state chose not to appeal the district court decision, had the right under Article 3 to be in court to argue in favor of Prop 8. So those are two ways that the court could resolve the case favorably for the plaintiffs without making a broad ruling on the merits. Now, that said, there seemed to be some degree of skepticism on some of the liberal justices' part as well as the more conservative justices about the narrow argument. And the skepticism seemed to be this concern that, look, if we say that California's laws that allow gay couples to have children and encourage that and give them all the same rights makes Prop 8 unconstitutional, it will be sending a message that will discourage the really terrible states from doing the right thing and moving in the right direction. And do we really want to do that? There are other aspects to the narrow argument that don't require the heavy reliance on California's state laws. It's a piece of it, but it's not the only piece. But, I don't know whether we're going to get the votes on that narrow ground. The standing arguments seem to get a fair amount of traction, and I think there is a significant possibility that we'll get a standing ruling, which is not the ideal, but it's certainly better than a loss.
I'm going to ask you a lot of questions about standing, but let me stay on this topic for a second. How much does it help as a practical matter that leaders of our country, former President Clinton, Republican senators, state ballot props that passed last fall, and all the people demonstrating outside in front of the Supreme Court, this seemingly wash in favor of marriage equality that's happened very recently? How much does it matter?
Well, I don't know. What I would say is that justices are human beings. That said, they are sort of rarefied, somewhat isolated from real people, so they're not quite as directly affected. But on the other hand, I know there have been gay people who've clerked on the Supreme Court, and so the more gay people that the justices know and get to like, I think that makes a difference. I think these changes make this difference. To the extent, and this is something I've heard other people say, and I think it's probably true, that Justice Roberts has shown a concern about the integrity of the court, and that he will not want to rule in a way that turns out to be the Plessy versus Ferguson of his court's day. And so I don't expect, I mean, it's really pretty clear if the tea leaves are telling, and you never know if they are, that is, if the statements or questions that got made by the justices are telling, I would not count Roberts in our win category on any merits argument. However, I do think there's a possibility that he will rule that there is no standing. Conversely, Kennedy is harder to call, and everybody says, everybody being the Supreme Court clerks, that his comments and argument are more opaque and you can't read as much into them. But he seemed, I saw a flicker of hope with him on the merits, although some reluctance, but he seems very much to think there is standing. So in order to get a no standing ruling, we have to get several of the liberal justices and Roberts, probably. And I'm guessing we won't get any of the other conservatives, but you know, you can't read much from Thomas's tea leaves.
Since he's completely silent.
Usually the conservatives are more, they like standing arguments, and the liberals don't. So it's an interesting.
Except he generally stands in line with Alito and Scalia, does he not?
Who, Roberts?
No, Thomas.
Yes.
Yeah. I confess I was among those who were unhappy that the United States Supreme Court took Perry. I wanted them to dodge it and leave it with the Ninth Circuit. And then I rethought it as I saw this whole tide of public opinion change so quickly, and I thought this might not have happened as quickly had the Supreme Court not taken this matter up. I don't know to what extent that's true, but it's given me pause as I consider whether it was a good idea or a bad idea. In any event, it's there. How would you have answered Justice Scalia when he asked, just when did this denial of marriage equality become unconstitutional?
Well, I'm not Ted, so answering a question with a question probably wouldn't work for me. It didn't even work for him, but he didn't get in too big of trouble for it. Scalia did say, don't answer a question with a question. But,
but then he answered.
But Ted used Loving versus Virginia, you know, like when did that right arise? I would have used a different case. And the reason is because, and Ted also did a fantastic job at argument, but Scalia's retort was, oh, I know the answer to that. That's easy. It's when the 14th Amendment was adopted. And in fact, that's not true, because if it was so clear that interracial marriage was banned by the 14th Amendment when the 14th Amendment was adopted, why did it take them until 1967, 100 years later, more or less, to get to that place? And I think the alleged history really shows of the 14th Amendment that there was not clarity at all about what the intent was on that issue. That said, it's really clear that nobody had gender in mind when the 14th Amendment was adopted. And so the better analogy that Scalia would have a hard time saying, well, that's easy, is, when did the rights of women to be treated equally in the workplace, under federal law, under state law, become a right? And I think the answer is, the best answer is Kennedy's language in Lawrence. And we got this question in the California Supreme Court too, by the way. And my answer was something along the lines of, Justice Kennedy said, times can blind us to certain truths, and later generations can see that laws that once seemed necessary and proper now serve only to oppress. So the idea is that our understanding of the principles in the Constitution and how they apply changes in time as conditions in society change, and as we learn new things about ourselves, about the world, about science, about all kinds of things. So the answer is the right, in a certain sense. If you're looking at a natural right, it was always there, or always sort of part of the constitutional principle. But we didn't see it. We didn't recognize it.
a piece of this is why should we decide this now rather than let it percolate for a bit longer and let states work on it further? And in the California Supreme Court, that was one of the questions posed to Terry. I remember her nailing it. And she said, because the question is before us now, and we need to decide it.
Oh, that was when asked, why do we have, why do we have to face it now, or why should we decide it now?
Mm-hmm.
Right.
Justice Sotomayor asked a question that I've listened to twice on this subject, and I still can't decipher it. I discerned no trace of irony in the way she asked this question, but she said, well, it took us between 1898 and 1954 to hold that racial segregation was unconstitutional. Why should we decide this now? Or I'm paraphrasing partly.
Actually, and I think that it was in response to something Ted said about the timing issue, and she was suggesting that the time between maybe Lawrence and the present, I forget, that there was a relatively short period between, I know, Ted said, referred to Romer as being sort of the time when the right arose, after Scalia pushed him like 5 or 6 times. And she said, well, the time between the 14th Amendment and Loving or the segregation cases was much longer. I couldn't read that comment either. I couldn't tell where she was coming from. I mean, the most logical reading of it, if you take away all the tone and everything else, would be she's saying, like, it took us a lot longer, why should we get there now so quickly here? She may have been addressing Ted's broad argument and about the idea of like taking this huge step relatively quickly. I don't think she's hostile to the plaintiff's position in general, so I don't read it as, you need to wait another 100 years.
No, I would have assumed she was sympathetic to the plaintiff's decision, that she would see this as obvious discrimination. That's my assumption.
Well, and there were other things that she said that suggested that, questions that she asked that seemed, but I do think she and Justice Ginsburg and not so much Justice Breyer, but Kagan, all sort of expressed this concern about acting too hastily and about pretermitting the orderly process and taking it out of the democratic process altogether right now. And so I think that's the best I can say about that comment by Sotomayor. But it was that one, and there was a Ginsburg one that I think I did figure out, but there were a few that you're kind of like,
yeah,
okay, I'll have to think about that, yeah.
So now you can talk about standing. You've argued from early on that there's no standing for the proponents. So the other side in this case are the people who put Proposition 8 on the ballot. And the city's argument has been, from the beginning, I think, that they don't have standing to raise this issue. They weren't injured by it. And maybe you've answered this in part already, but what was your strategic purpose in doing that?
Well, it wasn't from the beginning. In the beginning, they sought to intervene, as subsequently did we. And our view was you don't need standing to intervene. There's something called permissive intervention, which is discretionary on the part of the court and doesn't require that you be somebody who could bring the case yourself or defend the case yourself. When we raised the argument, first it was in the Ninth Circuit, and Ted raised it at the same time, although I'm not sure if Ted was aware, but one of his colleagues, we were responding to a request for a stay of the decision from the Ninth Circuit. The district court had issued his final judgment, and Judge Walker had said, I'm lifting my stay. And the question was, would the Ninth Circuit sort of reimpose the stay, leave the status quo, which it did do. So standing was first raised in that context. Our thinking on standing, well, first of all, legally, the proponents didn't need standing in the trial court because the Attorney General and the state, the governor and the registrar, of health statistics for the state had all been sued as defendants and were in the case. They may not have been vigorously defending, but they were enforcing the law and they were defendants in the case. But they chose then not to appeal the adverse judgment. So when we're on appeal, we no longer, the state's gone bye-bye, we don't have the state, so then the only group or entity on the other side of the case from the plaintiffs in the city is the proponents. So the question of their standing is suddenly there. And there was a case out of the U.S. Supreme Court called Arizonans for something or other. Official English, right. It was an initiative-related case. And the question there, in part, was, did initiative proponents have standing? The court ended up deciding the issue on something else. I believe it was mootness, and so didn't finally resolve whether initiative proponents have standing, but expressed in dicta very clear doubt about whether they did. So we thought there was a good argument there that they didn't have standing, and that if they didn't have standing, then the district court judgment would be final and we would have a victory, and why take a risk? It also turned out, and we didn't predict this, but the Ninth Circuit decided to certify the question of what proponents' rights or powers are under the state constitution with respect to representing the state's interests when the state attorney general and the state actors decline to defend. What's the state law answer to that question? Because they thought that that would be relevant to the question of whether they had Article III standing. So they certified the question, which added basically a year of delay to the case. And while that wasn't a reason that we raised the argument, I was pleased about that because I felt that the more time before we got to the Supreme Court, the better.
Turned out to be propitious.
It did.
The Supreme Court spent a lot of time in both cases on the issue of standing. And in Windsor, they went so far as to appoint its own amicus, a Harvard law professor, to argue that there was no standing in the Windsor case for the members of Congress who were asserting the constitutionality of DOMA. Are the standing issues alike in both cases?
They're alike in one respect and different in another. So there's two standing issues in the DOMA cases. One is whether the bipartisan legal advisory group that stepped in when the Department of Justice stopped defending DOMA has standing. But the other is whether the Department of Justice itself has standing. And the reason that's different from our case is because, unlike in our case where the state chose not to appeal, in the DOMA case, the Department of Justice appealed, and then even when they lost on or won on appeal, well, won or lost depending on how you look at it, they appealed, but then they argued for the plaintiffs. And then they sought review in the Supreme Court, and then they argued for the plaintiffs. But they were still a party in the case. Whereas the state, in our case, stepped out, said we're not appealing. So you have this issue of, okay, can the Department of Justice appeal, and does the government have standing even though they don't disagree with the plaintiffs? Is there a case or controversy? And then the second question is, does BLAG, the Bipartisan Legal Advisory Group, have standing? And there, it's partly a question of whether Congress has the power to kind of confer standing on this group. And there's real doubt about that. My take, and I read Vicki Jackson as the woman who the court asked to argue, because nobody was arguing that the DOJ lacked standing, everybody was arguing that BLAG lacked standing, but nobody was arguing that DOJ lacked standing until they appointed Vicki Jackson to argue both. And her brief was really good. She said neither had standing. My take, just again from the tea leaves of the court's comments, were that there's more support for the idea that BLAG lacks standing, but that a lot of the justices that seem to think BLAG doesn't have standing seem to think the Department of Justice did.
Somebody with a fiduciary obligation should have standing where there's a vacuum created by agreement. Or
Right, and you can create that, you can deal with the case or controversy issue by having somebody appointed to make the argument the other way. So even if Blag doesn't have standing, it doesn't matter, because they could be let in as an intervener or in a capacity like that to present the arguments, but the standing could still reside with the government.
What's your answer to the Justice's question that doesn't this give a new kind of veto to the executive branch that doesn't want to enforce a law or believes it to be unconstitutional? It's a separation of powers argument.
It is a separation of powers argument, and in California, it's an argument that it gives the executive branch the power to veto an initiative. So not just legislation, but initiatives which were created largely to go around the executive branch and the legislative branch when the voters feel like they're not getting what they want through those processes. I think it happens extremely rarely, and one of the ways to address it is to appoint somebody in place of the government. How it's come up in a number of situations and I was just looking back at an article today because I finally have been going through this stack of stuff that has been on my desk for 2 years that got too high in this case. And there's an article about the times that DOJ and others have declined to defend. And Justice Roberts actually did it when he was Solicitor General or Deputy Solicitor General, acting Solicitor General, something like that. But in a federal government context, sometimes a federal agency whose interests are at stake has continued to represent the adverse side in the case, even if the Solicitor General refused to take that position or even joined the position of the other side in challenging a law as unconstitutional. Again, you can deal with it through intervention, although ultimately here in Prop 8 case, because the state didn't appeal, but it's not a veto power there. It's not like the government said, we cave, we're not going to defend it all, nobody can come in. In the Prop 8 case, the government said, look, we're not wildly enthusiastic about Prop 8, we don't want to take a position on it, but we're happy to have the proponents come in and present the case. And only after a lengthy trial with full opportunity of both sides to litigate it and a judgment did they decide, okay, they're not vetoing it. They're saying we've decided that the district court got it right, and it was a fair process and a well-fought battle. And yes, there's a potential there, but I think that most government actors are very, government lawyers, government public law officers are aware of their responsibility to defend, and it's in, fairly rare circumstances where there's a serious constitutional problem where they have declined to do so, and there's been other ways to deal with it. Oftentimes, there are private parties with a stake in a matter. For example, in one of the race cases that the Attorney General of California came in on the side of the striking down the law was called Mulkey v. Reitman. And in that case, it was a proposition that allowed people to discriminate in housing and repealed all California's fair housing laws and said if you own or rent property, you have your full discretion to lease or not lease, sell or not sell to whoever you want. And the question was, was that a violation of equal protection? And the plaintiffs in the case were people who wanted to buy property, and the defendants were property owners. So usually the issue can be joined by people with a stake, even if the government is saying, we think the laws are constitutional, or we just want to stay out of this.
How likely is it, do you think, that the court will rule in either case that sexual orientation is sex discrimination or reach the merits on equal protection?
How likely is it, do I think the court will reach the merits? I think it's hard to call. I think it is possible we will get a merits decision. It could be a fractured merits decision. I think the way we end up getting a merits decision is if there's not a majority on no standing, which is, of course, essentially, they have to hold their standing in order to reach the merits. But what's really hard to tell is there a majority for no standing? But if there's not, I think we will get a decision on the merits. I am guardedly optimistic that it will be favorable, but I think it may be a weird decision that tries to avoid saying very much or giving a lot of guidance about future cases. And it may end up being like a plurality on a narrow argument, and maybe Breyer seemed amenable in a way to a broader argument. It's very hard to see exactly where they're going. Frankly, there was not enough discussion of the merits, and what there was both hard to read and a little troubling. So it's hard to know. Mostly what you got the sense was the people who are most likely to rule in our favor wish they weren't there.
This is just a process point. The justices were coming from all over, every which way in the questioning, and as I understand it, they don't have a case conference or a tentative opinion or something before they do oral argument. Is that correct?
Yeah, in the federal system, they don't generally have conference or draft an opinion before oral argument. In the state system, the opposite is true. So there's more potential for an argument to make some difference, although it's rare that it makes a huge difference. But my sense was there were still people who might be undecided. Maybe not all of them. In fact, I'm fairly confident not all of them. But there was enough kind of back and forth on different ways of getting there that I wasn't certain that everybody had made up their mind. And they certainly haven't conferred with each other and kind of hadn't as of yet.
Another strategy question. From the marriage cases forward, your office has encouraged the filing of amicus briefs and forward some, and provided some resources to people who do. What do you see as the benefits of having amici on your side?
Well, first of all, amici have the ability to present issues in greater depth than the parties can in the space of their briefs. So they can take a particular issue and write a whole brief on it, whereas in a party brief, you've got to address all the issues. But more importantly, I think there are voices that the Supreme Court is going to be more inclined to listen to. And there are people with expertise on issues that may make a difference to their decision. For example, we talked earlier about the American Psychological Association, Psychiatric Association, Psychoanalytic Association, etc. These
all
are
submitted briefs, I assume.
Yes, some group together and some by themselves. They don't always get along, sort of like lawyers, or they have their own perspectives, I should say. But also, I'm trying to think. The American Academy of Appellate Lawyers, or matrimonial lawyers.
Matrimonial
lawyers. Various groups. The corporation group that supported marriage equality. The CEOs, the super Republicans brief. The religious organizations. So it's two things. One, it's the substance and what they can present and how they can talk about it, and the historical perspective they might give, the parallels to race or gender or other issues, and also the who the voice is and whether the court's open to that voice. So we were trying to get people to write briefs that we thought would be helpful to the court, and where there was an organization or a group that wanted to do something but didn't yet have a firm, and we knew that there was a really terrific firm that wanted to do a brief, we were trying to do a little matchmaking. In the Supreme Court, you cannot, if you're a party, direct the content of a brief, and the people who write the brief have to say that you didn't fund it, you didn't prepare it, and so it's a limited involvement, but it's sort of, what you also don't want is 10 briefs saying the same thing different ways in a way that is counterproductive, or frankly at all, because it's kind of a waste and too much noise. And you don't want briefs that are going to say things that create a conflict with something that's important to your case or the way you're presenting it. So there's things like that that you can influence by getting involved.
There's a piece of appellate advocacy that I think is terrifically important and one that Terry has done well, and that is how you frame the question. What is the question presented? Often, it seems to me, how a court decides the issue is what they decide the question they're answering is. So the question presented, there were two in the city and county's brief. One is whether there was standing. And the other is, does Proposition 8 violate the Equal Protection Clause of the United States Constitution by extinguishing lesbian and gay couples' right to marry under the California Constitution for no purpose other than to classify them as unequal? It's a question not to ask, it's to answer it.
Yeah.
How long did it take you to frame the question?
You know, I remember working on it. It wasn't that hard. We wanted to reframe it in a narrow argument way because that's the argument we were presenting in our brief, and to pick up on each of the themes that were going to be part of our argument. And one was the stripping the rights after they had been recognized under the state constitution. One was, you know, not having any rational reason for doing it. And one was the animus and the prejudice that was infused in the campaign. And so, but you know, truth be told is the court grants cert based on whatever the, usually on what the cert petition says, and doesn't necessarily change it, except here they added the standing argument. And I don't know how much they pay attention to the questions presented. You try to frame them in the way that, as you said, to ask the question is to answer it, but I don't know that it is a big persuasive factor.
Okay. One of Justice Roberts' hostile questions was, isn't this just a label, marriage? You can say that I have to call somebody my friend, but if I don't like him, he's not really going to be my friend. Your brief answered that right at the outset. In many ways, this case is about a name, but what a name it is. How was that handled in oral argument?
My recollection is that Ted started to talk about the importance of the name and then and the word marriage, and then quickly got interrupted by another question. But it was, in a way, it's one of those questions that, while hostile, is a great opening. I mean, we got that in the California Supreme Court too, and Justice Chin raised, you know, a similar argument, and it was like, I felt like he gave me this chance to make my best case, because it is, I mean, part of the problem is that in California, both at the time of the state case and in the Prop 8, the lesbian and gay couples had all the same rights and benefits, or almost all of them, as heterosexual couples, except for the title and stature. And so the case is really about whether that title and stature is significant and why. And of course it is, and there's a lot of things to say about that. Ted did pick up on something that, poor Ted, I hounded him with ideas and thoughts, and he was very gracious about it. But he did pick up on one of them about a case called, and I think he may have tried to talk about it in the context of his answer to this question, and he also brought it up in other questions, which is about a case called United States versus Virginia. There are two cases involving denying access of, in one case, blacks and in another case, women, to very well-established, very prestigious institutions. In one case, the University of Texas Law School, and in the other case, the Virginia Military Institute. And the question was whether were the new institutions that the states created just for blacks and just for women equal in tangible respects, and even if they were, was that good enough? And the courts in both cases, the Supreme Court, you know, talked about the history and the tradition and the prestige that can't be replicated in a new institution. And so that case, you know, really supported the idea that the name, the title, the stature, and all that goes with it matters, has constitutional significance. But he didn't really get to give the eloquent version of that answer because I forget who.
He was cut off.
Yeah. That's the hazard of oral argument.
Well, you were there, and you were there for a couple of weeks before the arguments. What were you doing in advance of and preparation for this day?
We did 4 moots with Ted, and 1 with the Solicitor General, and 1 with Robbie Kaplan, the woman who argued the DOMA case. The moots with Ted ranged from sort of fairly internal ones with 1 or 2 people from the outside, and people from our team, and people from Ted's and David Boyce's team, and to one at Georgetown that was completely people from outside the teams. But you always want some outsiders because they read the briefs, but they're not steeped and, you know, they haven't drunk the Kool-Aid. So you want people whose perspective on it is more fresh. And they were really valuable. Ted got better and better and better. Before the moots, I gave him what I called my Q&A for him, which was like all the questions I sort of thought were the most likely to get answered in some form or another, and, you know, various proposed answers. And he said at the second moot, you know, I really appreciate your 19-page Q&A. And I said, well, I knew you had a trash can, so to the extent you didn't find it useful. But he was very gracious about being kind of, you know, given a lot of input and pushed on questions. And, you know, the Georgetown folks were really amazing, and Ted really liked the broad due process argument. But I think he didn't realize that argument is troubling to a lot of the justices, because to them it seems like there's no limits to it, and they keep coming to well, what about polygamy? What about this and that and the other? And how do you confine it if you start, you know, adding other types of relationships? And, you know, the argument, of course, is it's not a different type of relationship; it's the same. But the Georgetown folks really pushed him in a way that I couldn't, to focus a little more on equal protection and to bring that more into the argument, and he did. So you could see him evolve. And originally, I was going to split the time and have some of my colleagues come for a couple moots, and I was going to come for a couple. And then I thought, you know, the only way I can be useful is to see him through the whole of it. And then after every moot, I would type out sort of, you know, here's what the answer you gave to this. You might tweak it this way, or, you know, maybe a stronger answer is this. And he would read those, and he was really appreciative of getting them. And I do think it made a difference in the, you know, you have to be subjected to that. And I always did moots before the ones in the California courts, and they always made me better.
Any anecdotes or observations from just being there? The individual justices or anything?
You know, it was really nerve-wracking. We didn't know if we would even get in the courthouse because it was so sought after, both the DOMA argument and the Perry argument, that the justices we had asked, the folks in my office who clerked had asked their justices for some of their public tickets. I got my spouse Carol to join the Supreme Court bar about a month before the arguments, so that if we had to stand in line, we could stand in the Supreme Court bar line, which is shorter than the public line. But up until about a week before, we didn't know if we were getting really more than 1 or 2 people in. In the end, we got our whole team in with only paying 2 line standers. We didn't use city money for that. So that was both a relief and exciting and hard at the same time. You know, I think it's been a real privilege to get to work with the lawyers from Gibson Dunn, the lawyers, you know, David Boyce and his team, and Ted. And, you know, there have been times when we've differed a little bit, or there's been, you know, a divergence of views about strategy. And we've always managed to work it out and sort of smooth over the tense feelings. And you know, one of the greatest things about going there was Ted. They gave me a conference room, and I set up and worked from the conference room. And you know, as I said, I gave him input constantly, and my colleagues sat on the moot panels. And you know, we were very much a team, and the team came back to. We had been a team at trial, and we had really all brought different things to the table, and we had shared space during the trial at Gibson Dunn's offices here, and we were all back in Gibson Dunn's offices there operating as a team, and it felt really good. And it felt like the moments of friction were swallowed by the moments of shared goals.
If the court determines there's no standing in Perry, what does that mean as a practical consequence?
Well, what it should mean is that the district court's decision becomes final. The district court enjoined the state from enforcing Prop 8. The state has the responsibility to enforce the marriage laws. The county clerks operate as agents of the state in enforcing those laws. We may have some subsidiary, if you will, or ancillary litigation, because there's one county clerk in Imperial County who tried to intervene at various points in the case and has said that they will argue that they don't have to comply. I think they're going to lose, and if that will be slapped down fairly quickly. But I think we will. If we win on standing, it will be a win. Prop 8 will be gone, or if not gone, it will be have suffered a fatal blow that will eventually, in the short term, kill it. In other words, if there's ancillary litigation or anybody makes any questions about the scope of the ruling or who's bound by it, I don't think there's a serious issue there.
What effect, if any, on other states?
Only that California's the 11th, got I think 11% of the gay people in the nation. It's a huge part of the community. It will change the way, each state that has had marriage equality has lessened the hostility to it. And what's really interesting, I mean, when Carol and I were first together, we had a wedding ceremony that had no legal significance, and it was pre-domestic partnership in the state. And I didn't think we would see marriage in our lifetime for gay people. And not only did it kind of come to the fore in 2004, but the tide has changed so quickly. And all I can figure is that the internet and blogging and Twittering and all the ways that people communicate so quickly now have just speeded up the way that we think and the way that we process kind of conflict. I wish it could make us less polarized in some other areas, but in this area it seems to have been a good thing.
Thank you. You've answered all of my questions and enhanced my questions if you have any. Yes?
Going back to the issue in the oral arguments around, there was one part of the Prop 8 oral arguments that I was really confused by, was Justice Kennedy talking about the odd rationale of the Ninth Circuit. But it almost seems like he only understood half of what the Ninth Circuit decision said. It's one thing that it said, well, Prop 8 is wrong because California has all of these rights that gay couples enjoy, and we've taken away that, but then, if you're going to provide those rights for domestic partnership, you have to provide marriage as well. But the more fundamental point of the Ninth Circuit decision, which was really written for Justice Kennedy around a red bow, was applying the Romer precedent. Then that was what I was concerned about the oral arguments, is that we didn't really hear much discussion about Prop 8 is unconstitutional not because it denies the right of gay couples, but that it takes away a right the state had already put in place and removed it, very similarly to the way the Colorado initiative that was overturned in Romer did.
Yeah, and I agree. That troubled me too. But I'm told that, and again, this is like complete gossip, so I don't know if it's true, but that Kennedy and Reinhart are not the best of friends, and that that it may have been a little bit of a dig at Judge Reinhart, who wrote the Ninth Circuit opinion, and also that Kennedy, you can't be sure that what he's saying necessarily reflects his thinking on the merits. So I'm hopeful that it doesn't mean that much. But yes, I agree. They focused on, I mean, they were worried that if you adopted all of the Ninth Circuit ruling, that it would disincent states who don't have much recognition or any from progressing in their laws, and that it would, quote, punish the states that have done the most. And that is an ironic aspect of a part of that argument. But you're right, there are other facets to the argument, including the stripping of state constitutional rights from one group alone that makes it very Romer-like, and the fact that you can't figure out any reason for it other than animus. And that animus was actually really, or prejudice at least, very apparent on the surface of the campaign and the ballot materials and everything else. So we'll see what he does. I'm just sort of hoping that the people who say that his remarks are of limited value in intuiting what he might do are correct.
Yes.
Terry, anything less than the really broad ruling on the merits seems like it's going to really raise the temperature around the full faith and credit clause element of DOMA. Because even if we strike down Prop 8, California is allowing, the other states are allowing marriage equality, we're going to suddenly have the issue of whether or not other states are required to recognize it, especially if we do away with the one provision of DOMA. Do you know if there's much progress on challenging the other provisions of federal DOMA?
My understanding, and this comes from having briefed a weird issue on full faith and credit for the California Supreme Court and calling my former Professor Herman Hilke and saying, help! We don't have a very good argument on the full faith and credit aspect of DOMA because the full faith and credit clause has two aspects. If a court in a state enters a judgment, then the other states must honor that judgment. But if a court in another state applies a policy or a rule or even adopts legislation that isn't a judgment, the other state has a degree of discretion, and if it has a policy that is directly contrary to the policy of the state in question, it doesn't have an absolute obligation. So in marriage, states have always been free to reject marriages from other states, and sometimes have, because their policies were different. So I think the full faith and credit issue is not a great, I think that's why people like Mary Bonanno and the folks who challenged DOMA didn't focus on the full faith and credit part. It's not a great argument. It works for adoption, for example. So if you're, one of the things people in California who advise clients on this issue, they say don't rely on the presumed parentage statutes in California because they protect you in California and the relationship of the non-biological parent to the child. But if you go out of California, since you don't have a judgment, you can't enforce it. So you should do an adoption because an adoption results in a judgment, and that is something full faith and credit requires be honored. So it's a long answer to a short question.
Yes, in the back.
When I was listening to the podcast of the argument, there seemed to be times where the lawyer who was arguing on behalf of the proponents, when he got asked about the merits, was kind of a little flabbergasted in trying to explain like what the basis, the rational basis of it was. Do you think that had any effect on any of the justices? I
think it has all along in the case. I mean, it's interesting. I got asked a question yesterday. I was talking to a group of students at Bolt, and this guy said, do you think that the lawyer, you talked about the campaign, and he used the term dog whistles, that during the campaign they were drawing on prejudices by making arguments about children and drawing on these old ideas that gays were pedophiles and molesters and so forth. And he said, do you think Cooper, the lawyer, representing the proponents, was sort of doing any dog whistling along the way to the courts? Meaning, trying to draw on prejudice. And I think Cooper did the opposite. I think Cooper was very aware that if he made certain arguments that were made during the campaign, that were actually front and center during the campaign, there's no way you get away from the fact that they basically are arguments that are prejudice-based. When you say protect your children from gay people, there's no way to describe that argument that doesn't end up boiling down to prejudice, even though I think people didn't see it that way at the time. So he tried very hard to make, and he also knew that the procreation arguments, he made them, but he made them softly because they don't fly very well in California because of the backdrop. You know, how can California claim an interest in having opposite-sex couples be parents and not gay couples, given the rest of its laws, and given that its whole parentage scheme is actually quite separate from the marriage laws for the most part. I think he wasn't left with very much. So his argument was this rational speculation of some hard to pin down, identify fear. And I think that that's why a trial was good in this case. We put discrimination on trial, and he did. There's no good answer. There wasn't a good reason. And it came out, and we peeled the layers back of every argument that got made to show either that there was nothing there or that what was there was about prejudice. And so I think that's the strongest thing we have in our favor, is they don't have a good argument about what harm will be done by allowing gay people to marry.
Thank you all. That concludes our presentation.
Thank you.